is de belangrijkste spreker die denk ik van hier zal spreken, dus ik zal hem gewoon inleiden en dan kan hij misschien hier staan.
Ja, maar als een spreker liever een headset of een handmicrofoon heeft, dat ook goed.
Do you like, do you prefer a headset?
Ja, mijn preferentie is om rond te lopen.
Ja.
Dat is misschien beter zo.
Ja. So I will briefly introduce you from here and then you can use
Yeah,
the headset.
that's perfect. Oh, I've noticed this. I always use the same microphone, but I've never. Is it correct?
You have to put it over your ears.
Okay. So.
Yeah, like that. Okay. And it's already on, so.
Yeah,
Okay,
then
then
just
mute
turn it
it.
off and then you can turn it off.
It's really amazing. I spent 20 years with exactly this.
Okay, dus we gaan.
Die weg weet. Dus,
Oké, dus is goed. Dus dan als je klaar bent, dan gaan we starten.
ja, wel mee is het.
Okay. Good evening, ladies and gentlemen. Welcome at another meeting of our Russia platform, another lecture, which will be again organized in a hybrid form. It means we have some people here physically present in the room, so particularly welcome them for coming to Ghent this evening, but we also have quite some people watching from home following our live stream. The Russia platform's live stream options are still available, so I'm also welcoming the people who are currently following our public lecture from home. So I'm very grateful that we have a distinguished guest this evening, which is Professor Dimitry Kochenov, who works currently at the Central European University as the Democracy Institute of the Central European University, and who is well known for his work on European Union citizenship, on questions of rule of law as a very topical issue these days within the European Union. But this evening he will talk about constitutional developments in Russia. The title of the lecture is Constitutionalizing the Disregard of European Court of Human Rights. So the lecture will concern Russia's approach to human rights, the role of the European Convention on Human Rights. So we're very much looking forward to this public lecture, and I'm sure that there will also be a possibility for some questions and answers after the lecture. So without further ado, Dimitry, you have the floor.
This is Yeah. This is wonderful. What an honor to be here. Thank you very much for the kind invitation. The title might seem to be about Russia, but in fact it's not necessarily about Russia. So what I aim to do while discussing some Russian case law and also CVHR case law is to bring us to a grander picture of Europe that is currently emerging. And especially what I have in mind, and I have the number here, is the development from today's morning when the Polish Prime Minister sent a special request to the so-called Polish Constitutional Tribunal, which we know is an unlawfully composed body which pretends to be a court. But there are individual decisions already about several members of that so-called court that they are not appointed properly, and that they are not judges in the eyes of the European human rights protection system, which means this unlawful court today received a request from the office of the Prime Minister of Poland to rule on the legality of the ECHR in the context of the Polish constitution. And this ruling to come will clarify whether the Polish constitution will prevail, especially on the matters of the lawfulness of composition of the tribunal, which is about to rule on the legality of the ECHR. So it's an absurd development, of course, but for Poland it's not something new, because if you have been following the story a little bit, the same unlawful quasi-tribunal, which using US case law language we can call a kangaroo court, this kangaroo court has already ruled that the European Court of Justice is not the proper body to secure supremacy of European law. And that supremacy of European law is actually not the principle that should necessarily apply in Poland, because there are problems with especially Articles 3, 19, and plenty of others of the Treaty on the European Union. If you remember what Articles 3 and 19 are about, this is basically all, and also Article 2, of course, this is basically all what official values of the European Union, as we know them, stand for. So democracy, the rule of law, the protection of human rights, impartial independent tribunals at the service of the citizens, all that is now, well, against the Polish constitution. So we have the Polish example, and my basic claim today is that this Polish example should be considered in the context of the Russian precedents and also in the context of the precedents coming from the European Court of Justice. So I offer a more general picture of approaching this stalemate in the dialogue between different levels of the judiciaries in Europe than the majority of scholars who would focus on one jurisdiction. So to me, focusing on Poland is extremely interesting, yet to understand it fully, we need to focus also on Luxembourg and also on St. Petersburg. So now coming back to Russia, what interests us the most today. Of course, I'm not really an expert in that particular legal system, although I had my first law degree there, and I qualified there under a different constitution. That different constitution is nevertheless the current constitution officially of 1993, which came about as a result of a referendum. It was a document which was born with plenty of hopes, and which meant an absolute and total reshuffling of all the core principles of Russian law as they stood by the moment when the constitution came to being. And what interests us now from Belgium and from Europe is mostly the relationship between international law and Russian law, and as opposed to the Soviet principle of absolute dualism, and basically almost the theoretical non-existence of international law in front of the local courts throughout the Soviet Union. Now, in 1993, Russia received a constitution which is absolutely monist. So international law suddenly becomes directly enforceable, enjoys supremacy, and can be invoked in front of all the levels of the judiciaries in all the subjects of the Russian Federation. It's a 180% degrees U-turn. So it's a remarkable and in fact it's an astonishing development. So the constitution has been amended most recently in 2020, last year, and plenty of scholars reacted to those amendments in an unusually harsh way. What are those amendments about? If we speak about monism and dualism, the amendments try to qualify this absoluteness of the monism as introduced in 1993. So, do they go against monism? Not really. Monism is still the core principle. But they say in some particular, very special circumstances, it can be that the Russian constitution will prevail above an international agreement previously concluded, or the decisions of international courts and tribunals, which come to being under one of those agreements. And of course, it sounds a little bit illogical for a monist country, but the amendments themselves, the amendments to the constitution, don't depart from the case law of the Russian Constitutional Court. Because the Russian Constitutional Court has said on a number of occasions, and I will walk you through the key decisions, that although the fundamental principles on the basis of which the European legal orders function, including the Russian Federal Constitutional Legal Order, including the ECHR, and presumably including all the others, like the civilized European legal orders, are the same. So the starting point is that there can be no direct conflict whatsoever as a matter of principle between the Russian Constitution and the ECHR. But on some occasions, there might be instances when the view of certain matters would be irreconcilable. And they flagged them in a number of decisions. So the first one was, of course, triggered by the continuation of the Hearst saga. And what I'm telling you now is drawing very much on a little article which I wrote together with Professor Konichenko from the Kutafin Academy, well, now Kutafin University in Moscow, former VUZ, Всесоюзный заочный юридический институт, one of the most prominent legal schools over there, who tried to dig into the origins of the current position adopted by the Russian Federal Constitutional Court, and everything starts with Hearst and with Anchugov and Gladkov, where the European Court of Human Rights told the Russian Federation that it was unlawful, as many of you would already know, to disenfranchise prisoners automatically. Of course, we might say, great, it's a fair point, it's a valid interpretation of the European Convention on Human Rights, but besides this absolute monism that is part of the Russian Constitution of 1993, there is also a crucial, fundamental approach to protecting the essentials of the Russian constitutional order, which is a core part of the same document. And that means that some parts of the Constitution are unchangeable. It's impossible to amend those parts. So you cannot abolish the federal nature of the Russian Federation. The Constitution absolutely prohibits it. You cannot abolish or amend the core rights of man and citizen in the Russian Federation. And the Constitution expressly states in that part which is unamendable that unfortunately those who are in jail will not enjoy the democratic rights which the free Russian citizens are entitled to. So if we take the position of the ECHR seriously, then we have to agree that the ECHR can overrule the unamendable nature of a particular part of a constitution of a member state of that system, and that even though it's impossible to amend that part of the constitution, the reading of the ECHR provided by the court will then be given bigger legal weight than the crucial starting point adopted by the drafters of the 1993 document. And this is something that is difficult to do. So what happened after the ECHR came up with this decision, and I think we should legitimately question how far judicial restraint should actually be practiced in Strasbourg in order to make sure that the framing of rights happens in such a way that the implementation of those rights will not be absolutely impossible in the national legal orders. So the care is always required, especially in this context where no overwhelmingly important right, like the right to life, etc., was actually in question, and especially in the context when the Hearst saga was not resulting in particular successes on the UK soil, and especially in the context that we see the same kind of deprivation of political rights happening in even in plenty of other member states, or then member states of the European Union. So it's a difficult and probably unnecessary move, which nevertheless opened the gate for the Russian Constitutional Court to start thinking about the doctrine of questioning the interpretations and the supremacy of the interpretations of the CHR over the national constitution. And of course, all kinds of nationalist politicians jumped on this train. So immediately, several members of the Russian Duma, the Russian Parliament, requested the Constitutional Court to rule on the validity of a number of federal laws that automatically required compliance with the decisions of the European Court of Human Rights. So we can question the scale of compliance in the Russian Federation. It's not actually high, but the fact that Russia is involved in the system unquestionably benefits the level of rights protection in that country, however imperfect that level should be. So what was happening under the pretext of this overreach, as it was viewed, of the ECHR, was de facto an attempt to bring Russia out from under the umbrella of ECHR protection through the case law of the European Court of Human Rights. And the court didn't bite. So the court came up with an opinion 21P of 2016, which was immensely criticized in the literature. So some scholars even wrote it was Stalinist. Some scholars wrote it was absolutely unacceptable. It should have never happened. I don't think at all that it's Stalinist, and neither Professor Krinichenko, my co-author, because what the court has done, the court has forcefully reaffirmed the principle of monism, which is the essential element of the Constitution. But it pointed in the direction that in some really, really narrow set of circumstances where it's impossible to reconcile that principle with what is requested of the constitutional system, there could be a departure from what is required by ECHR case law. Of course, it's a violation of ECHR law. And of course, it's a violation of international law. And of course, it's a violation of the principle of monism, but it's framed in such a way in direct departure from what the nationalists and the fetishists of sovereignty, so-called, hope to receive from the court, that in fact we can say that they lost. And the spirit, at least in part, the spirit of the 1993 Constitution won. But of course it was just an opening. And as the case law was developing, we can say that the whole context of the narrow reading of these departures from ECHR was entirely deteriorating. So the next case that comes to mind is a response to нефтяная компания Yukos versus Russian Federation. When, well, of course, if you steal a business and you lose arbitrations, and also you violate rights, you're brought to justice in Strasbourg. Russia was supposed to pay 2 billion to those who were unlawfully deprived of their business. And then suddenly the Ministry of Justice that failed to comply with this decision brings a case to the Constitutional Court of the Russian Federation, asking the Constitutional Court to rule that that particular case was actually very similar to the previous 21P, when the Constitutional Court ruled that the unchangeable part of the Russian Constitution was at stake. There is nothing unchangeable about paying for paying what the European Court of Human Rights asks you to pay when you fail to respect your obligations under the CHR. No obligations which would be comparable to the previous case were at stake, and yet the Constitutional Court obliged. So what we see is that the case law is going in the direction of a slow deterioration of the very idea of compliance under the pretext of these narrow deviations from the general principle of monism in the Russian constitution. Of course, there were two members of the Constitutional Court who dissented, and in their dissents, they clearly state that it's impossible to consider admissible a case which is brought to them by the Ministry of Justice as a cover-up for the willful failure to comply on the part of the ministry with the obligations under the CHR. But whether we want it or not, the situation as it stands, with the amendment of the Constitution, with also legislative amendments related to the status and to the powers of the Constitutional Court of the Russian Federation, is such that all this case law was taken on board and became part of the body of the current Russian Constitution. So what is possible de facto in the majority of in all the member states of the European human rights protection system is now possible de jure in the context of the Russian system, where non-compliance is one of the options offered by law to the Constitutional Court. And then Poland learns from this. So the kind of arguments that we hear from the Polish so-called Constitutional Tribunal is that it's absolutely indispensable to guarantee the supremacy of the Polish Constitution over international law, and including European law, that this is something that is in the nature of the Polish national legal order, which is built in order to safeguard the rights of all the Poles in Polish territory, even in the context when international or European law is hostile to Polish interests. This kind of logic is the same, but the context is very different. And the first difference that catches the eye is the fact that the Russian court, however convincing its rulings or not convincing, is still unquestionably a lawfully composed court in the eyes of the CHR. So when you think, especially after the response to the Yukos case in the Russian legal order, when you think that it's impossible to fall lower, Poland actually provides a helpful example that we are not there yet, and it's like the Russian saying where you reached the bottom and then someone knocked from underneath. So it's always possible to fall lower. And now the Polish unlawful courts use exactly the same kind of reasoning in order to get where the Russian legal system got via legal means. And in this sense, if we look at in general the crisis of the rule of law in the context of the EU, we have two core examples there, Hungary and Poland, that show two different ways to the same, from the same point of departure to the same point of arrival, which is absolute non-compliance and ultimately legal anarchy at the national level. But the two ways pass through absolutely different landscapes, because one landscape is absolute neatness from the point of view of legality, while another one, and that's Hungary, where no outright violations of the national constitution or any part of the legal system were committed as part of the crusade against the basic idea of the rule of law as applied in the Hungarian Republic. The second example is Poland, where basic legality was never respected and no one even tried, even vaguely, to make sure that the courts are lawfully composed, that the law is taken into account at all, and that the arguments that are deployed make even the vaguest sense. So if we have these two extremes, then Russia would be somewhere in the middle. And this middle is not necessarily a golden middle, because all the three examples ultimately bring us to exactly the same sobering reality or sobering realization that there is a trend of deploying law legally or illegally, lawfully or unlawfully in the European legal space in order to minimize the impact of the European Court of Human Rights on the national legal systems participating in the Council of Europe. The arguments are always the most basic arguments. Our constitution is supreme, our constitution is perfect in terms of the protection of human rights. So if the European Court of Human Rights deviates too much from our constitution, post facto, way after we acceded to the convention, then probably those deviations will not be binding as long as they destroy the purity and neatness of our constitutional legal order. So there are three examples. Russia is the golden middle, and all that, in fact, is very worrisome. And there is a fourth example. So enters the European Union, enter the European Union. And I will read two tiny quotes if I find them. So the Russian Constitutional Court, in its decision 21P, justified its position in the following way. So positions take, this is, I'm reading directly from a non-official but still close to the text translation. Positions taken by the CVHR containing analysis of national legislation or presupposing the need of legislative change do not cancel for the Russian legal system the supreme value of the federal constitution and can only be realized within the framework of the Russian Federation legal system as established by the document. Fair enough. So we have a monist legal order. Yet this is the legal order we work with. So we can use the very existence and the functioning of that legal order in order to fend away the perceived attacks in the name of human rights. And then we don't really need some far-reaching arguments. We simply say we don't want to pay 2 billion. And the European Court of Justice, in opinion 213, deployed the following reasoning in order to make sure that the European Union doesn't accede to the European system of protection of human rights. Paragraph 184. In particular, any action by the bodies given decision-making powers by the ECHR must not have the effect of binding the EU and its institutions in the exercise of their internal powers, thereby undermining supremacy and functioning of EU law within its own sphere of competence. So we saw the core difference between what the Russians are doing and what the Poles are doing in trying to block the effective application of the general standards of human rights protection to their own citizens or to those who are within their jurisdiction. The Russians would simply say our law is supreme, but they will use a lawful court to do that. And they will be members of the CHR. The Poles would say our law is supreme, and they don't have a lawful court. And they would still pretend that they do, because they don't care, because they want to get out of the CHR de facto, but they will remain formally members of the CHR, awaiting the decision of this kangaroo court based on today's application. What does the European Union highest court do? It deploys exactly the same reasoning via a lawful court, but in order not to accede to the CHR. So while the starting principle then of the Russian Constitutional Court is that possible conflict is almost impossible, our system is absolutely monist, and we will take whatever comes from Strasbourg unless you make us pay 2 billion or unless you want to rewrite the unchangeable part of our constitution, but still we're in. And the starting point of the EU, speaking via the Court of Justice, is that we have to be out, because otherwise we will need to eat your understanding of fundamental rights, and we will need to somehow readjust our understanding of the internal market with something else in mind rather than the objectives which are set in Article 3. I don't want to make any kind of scales of what is worse. Some would say being in but spitting on the system is worse than being out and still providing a high level of protection of human rights. Others would say being out on the same reasoning as is used by others to spit on the system is probably not as adorable as an option, and thus is not worthy of enjoying the second place in this list of anti-fame. It doesn't matter for us what is worse. What matters for us, for the purposes of constitutionalizing the disregard of the European Court of Human Rights, is that the same kind of sovereignist reasoning is used by very different bodies, some of them unlawfully composed and some of them are not courts, which have different prestige in our eyes, and yet the final outcomes and the final goals to be achieved are absolutely the same. So while we cannot say that the European Court of Justice really has the disregard of our fundamental rights as one of the fundamental goals of its existence, the literature on the fact that it's not a human rights court is huge. So the European Court of Human Rights, the European Court of Justice, becoming a human rights court would obviously boost the rights of all the European citizens. Not doing it under the same pretext and almost the same wording as the Russian Constitutional Court when it disregards the binding effect of the decisions of the European Court of Human Rights within the Russian respective system is to me too low compared with the basic expectations, the basic threshold that we should have as European citizens vis-à-vis the core court in our system. And then the same kind of problems can actually be extended further. And here, it's probably too technical, it's arraigned, but once we start comparing the ECHR, the Russian Constitutional Court, and the Polish courts, and once we start scrutinizing the appointment system, some really unkosher revelations immediately come to mind. And what I have in mind with regard to the Court of Justice is the story of Advocate General Sharpston and how exactly she was removed from office, and how exactly the Greek so-called Advocate General was appointed in direct contradiction of all the rules of primary and secondary law, as well as basic judicial protection guarantees. So when you proclaim a principle of irremovability of judges as one of the sacred elements of Article 19 under EU law, and request everyone from the Spanish tax tribunals to the Polish Supreme Court to the Conseil d'État and all the others within the ambit of your powers and your interest to observe that principle while you don't observe it yourself, then questions start arising. Because then we cannot anymore say that opinion 213 by the Court of Justice is somehow so radically different from opinion 21P from 2016 of the Russian Constitutional Court, or from what the phony Polish Constitutional Tribunal is actually doing. And the basic point that I'm trying to make is that this kind of skepticism, which is not properly justified of the basic guarantees which are provided for in the European system of protection of human rights, and the court in Strasbourg, this kind of rot actually is much more widespread than where Professor Lauri Marxo, for instance, an Estonian member of the Venice Commission, who writes about the Stalinist nature of Russian skepticism vis-à-vis monism, than what he would proclaim. This kind of skepticism is much broader, and in this sense, if we agree that it's much broader, then the question of the basic expectations come to mind. So to what kind of standard should we hold the Polish fake tribunal as opposed to the European Court of Justice? And here I think the European Court of Justice owes us much more than those individuals who were proclaimed to be already unlawfully appointed, who are already known judges, and whose scribbles, legally speaking, can have no lawful effect, as we read in Xeroflor, as we read in Zurich, if we look at Luxembourg, and as is absolutely clear to any minimally legally trained individual. So the problems are plentiful. The tools of creating these problems are really quite miserable, intellectually speaking. You simply say we have a sovereign system, and our goal is to safeguard this sovereignty. I apologize. So let's look in all directions where these problems are coming from, and try to understand how this reasoning migrates, how the Russian court will learn from the European Court of Justice, how the Polish fake tribunal will learn from the Russian court, etc., etc., etc. So I would like to end on this really sad note, and that sad note is that everybody's afraid of human rights when they can endanger the day-to-day functioning of their own legal order. And it's not only the Russians, and it's not only the Poles, it's also the European Court of Justice itself. And the latter is something that I find particularly sad, given that, of course, it's not a fake Polish tribunal. So thank you very much, and I think we should open the floor for questions, right? And I invite you to read the small paper that I published in the International Legal Materials, which is one of the Cambridge journals. It's the journal of the American Association of International Law, on the latest amendments of the Russian Constitution, where I say the amendments is something that we should frown upon, as if we believe in the importance of human rights, but we should not take them out of context, and we should regard them also in the context of what's going on in other legal systems. So the problem is not only Russian, the problem is much bigger.
Thank you very much, Dimitry, for your lecture, particularly for the comparative analysis, the comparative approach to the case law of the Russian Constitutional Court, enlightening us a little bit and providing a little bit context of the cases where most of us, I think, already had some basic knowledge about and were confronted with in recent times. So I'm sure that this also leads to some questions, comments from either the people attending the lecture here in Ghent, so maybe the people watching at home. I know that Anna is following the chats. When there's something at home, you should warn me. And maybe first give the opportunity to the people who are attending this event here. Are there any questions or comments that that you have that arise?
Before the comments come, probably the very last point I wanted to make, and that is that both more so probably the European Union legal system than the Strasbourg human rights protection system, but also the Strasbourg system, are based on the idea of the dialogue between the judges belonging to different levels. And here, if we look at the nature of this dialogue, in the context of EU law, it was constrained to a huge degree by the stricter and stricter interpretation of the notion of a court by the Court of Justice. Of course, if you don't qualify as a court, if you're a Spanish tax tribunal, if you are some special committee within a particular protected profession, you used to be a court, now you're not anymore. You are still supposed to apply EU law in full, but you cannot engage in any kind of interactions with the Court of Justice. Now that the Court of Justice is much stricter, more and more bodies are not able to ask questions. And the second side of this coin is that if you are a court in the eyes of the Court of Justice, then not asking a question can be a crime, quote unquote. So think about there was a relatively recent case, Commission versus France, where France was brought to court by the Commission for the absence of a preliminary ruling question. And this is a totally different dialogue now compared with the dialogue on the Silfit, the dialogue on the Acte Claire, when the national courts could decide for themselves whether they would actually open their mouth and start speaking. Now they don't have this right, and plenty of those who would like to speak are not welcome to do so. So the dialogue is not the dialogue of equals anymore. And here the Russian constitutional practice is quite revealing, if not, well, it's also amusing given what they do, what they use it for, ultimately, because the outcome is exactly the same like in Poland, exactly the same like in Luxembourg. But the Russian Constitutional Court said in one of the opinions that I cite in the piece I recommended you to look at, that the dialogue, which is not a dialogue among equals, is per se impossible. It would be ridiculous to invite the Russian Constitutional Court to engage in dialogue about fundamental rights if the outcome is always the same, that the European Court of Human Rights, whatever reasons it provides, has to prevail in its understanding. And this is something that certainly could apply to the dying out dialogue in the context of the European Union. The last thing about dialogue, unlawful bodies, especially from Poland, now try to engage in it in order to provoke some kind of indirect recognition of themselves as judges through this participation in dialogue. And this is something that is as worrying as shutting the mouth of some local body that used to qualify as a judge, or as imposing dialogue when it doesn't emerge naturally, as it were, between different legal orders. So what we see is so-called judges from the kangaroo courts, which are already proclaimed usurpers by the European Court of Human Rights, sending questions, which could be the questions, actually arising questions of EU law, to the Court of Justice, just in order for the Court of Justice to reply to them, thereby giving a hint that it might be the case that the European Court of Human Rights was too harsh in proclaiming that they were not actually lawfully appointed judges. And this is a very big question. It's a very, very big problem. For now, we have one such case where we have an opinion of Advocate General Bobek, a nihilist, highly unhelpful but brilliantly drafted opinion that says national legal systems are like a salami. If you cut the salami, it can be more or less good, but then at a certain point, you come to the point where there is a bad slice. And that bad slice, unfortunately, doesn't justify from not calling the salami a salami. And I think this approach is absolutely unacceptable. So once we deal with the abuse of the legal system, we need to be able to call it as such. And once we deal with the abuse of the idea of dialogue, we should also be able to call it as such. Now I shut up.
Thank you. Again, I invite for questions. I have some questions, maybe remarks myself, and then come to the audience again. One is maybe more special question about the current state of this Yugo saga you refer to. I mean, what is the current state? What are the implications? We refer to the Russian Constitutional Court, but are there any recent developments? How will this end? Will this just be a refusal to comply with the European Court of Human Rights judgment, or any other options still possible to envisage? So that's perhaps a more specific question on that particular case. And then perhaps a more general question where you made some comparisons between the so-called Polish Constitutional Court, as you mentioned, and the Russian Constitutional Court, where you made a distinction, arguing that the Polish Constitutional Court is not a true court because it doesn't satisfy the requirements of independence. And if I understood you correctly, you refer to the Russian Constitutional Court as a proper true court in the legal system, but aren't there any questions or possible remarks to be made about the independence of the Russian Constitutional Court in terms of appointment procedure and the way it works? Or what are the differences there? That would be the second question I have.
Brilliant questions. So fortunately, the thresholds in the European human rights protection system are very low. So the Council of Europe always gives you, the Convention always gives you the minimal set of requirements, of course, as interpreted by the European Court of Human Rights, as clarified by the Venice Commission, etc. This is the minimal set. And the diversity within the system is such that if you start being too strict, then probably you will brand out as deficient too many potential collaborators in your task of bringing about a better state of the safeguard of human rights in the context of all the members of the international organization. So if you are too strict, then the system is going nowhere, and you deprive people who need human rights, or where they are, of the last chance to get their human rights protected. So I applaud the case law that says that the president of Azerbaijan is a proper legislature. I applaud the case law that says that some courts on the island of Barataria, to allude to one advocate general, are actually proper courts to send questions to the European Court of Justice, or proper courts to be considered courts in the ECHR legal system. Branding courts as deficient can be too costly in the long run in order to engage in this activity too easily. So for now, we have a handful of cases, now 3 cases in front of the court, decided in front of the Court of Human Rights regarding Poland, where the Court of Human Rights simply said, these guys are not judges. And the Council of in the last one, the Council of the Judiciary that appointed them is not a Council of the Judiciary. It's easy to check why. The court comes up with very clear reasons. The court shows that the national constitutional system is in such poor shape that it's impossible to rectify the situation, and the court also demonstrates that what it hints at is not only the court's position, but is a general opinion among the scholars and among other bodies within the sphere of application of ECHR law. So when we speak about the Council of the Judiciary in Poland, the Neo Council of the Judiciary, as it's called in the literature, It was even kicked out from the European network of the councils of the judiciary for failing to meet the basic requirement of independence. When we speak about outright unlawfully appointed judges who are appointed by an unlawful institution with direct violation of the Constitution and all the legal framework, then this is a radically different level of unlawfulness compared with suspecting somebody somewhere in the less performing part of the ECHR legal geography, let's say, less performing from the point of view of human rights, of the lack of independence. So Polish courts now, for better or for worse, are much worse in the eyes of the ECHR, in the eyes of the European Court of Human Rights, than the courts in Azerbaijan, than the courts in pretty much any member of the system. And well, we cannot compare with Belarus because it's the last remaining non-member. So I think it would be unfair to say that the standards that are applied by the ECHR to Poland are somehow too strict as opposed to the standards applied to Russia. We don't have a single case, to my knowledge, that would say that a member of the Russian Constitutional Court has been appointed in a flawed manner outright with a direct violation of the Constitution and with a indirect violation of the basic legal framework of the Russian Federation. These things don't exist. But again, as I said, there are different ways of ensuring slow departure from the high levels of the protection of human rights as demanded by the ECHR. You can adopt the Hungarian way, where there are plenty of flawed appointments, but the de facto flawed appointments. But these de facto flawed appointments are made in a de jure neat and absolutely lawful, legalistically lawful way. And there are Polish examples where the situation is radically different. So again, probably Russia would fall somewhere in the middle, but it's reading the case law of the European Court of Human Rights, we will not necessarily see that, because once again the threshold is very low, and in the situation of a low threshold, which once again is great, because in theory the lower the better, because otherwise you de facto fence off countries. But somehow you need to establish the minimum, and when plenty of members of the panel that is about to decide that ECHR law should not apply to a particular country because of the Constitution. ECHR law is such, which is the question in Poland, not a particular judgment of the Court of Human Rights, which was the question in Russia, then I think that threshold is quite the right one. You simply need to say outright, this kangaroo court is composed of fake imposters, of imposters who are not supposed to be robed as judges, and who are basically stealing our attention for nothing, because as the Court of Justice has already ruled, any decision of the court in this kind of composition, any national court in this kind of composition, that in the English translation it was null and void. That's the case of Jurek, but the linguistic versions in all the other languages go much further than null and void. In French, they say something like n'a jamais venu. So something that has never happened. It's not simply annulling a decision. This is an absolute absence of the decision that we are facing. And so in the context of the absence of the decision, all the Poles are in trouble. Because now the only court in Poland, which above the level of the lowest court, which are not yet hijacked and absolutely corrupted, becomes the European Court of Human Rights. And you cannot run the country with one court at such a high level. So to me, Poland is the biggest problem. But the trend is exactly the same. And once we look at this issue from the standpoint of principle, then the European Union emerges as the biggest problem. Because I still think it's a matter of pride of the national, of a particular constitutional system. You have to recognize, following the late Dworkin, in one of his last articles, that you are better off as a legal system if you do have external constraints on the absoluteness of your national power. Whatever those are, coming from international law. So to claim that you don't need the ECHR while you are a European constitutional system is a claim that, that cannot be if you treat the basic idea of human rights protection and rule of law seriously. It's the Belarusian claim. And nobody wants to be Belarus besides the European Union that honestly seems to believe, speaking through the mouth of the Court of Justice, that it is quite fine without precisely being subjected to this external system of additional checks concerning the adherence to the basic, extremely low human rights standards. And in this sense, I do believe that if the European Court of Justice ever complied with the direct requirement, which is black on white in the treaties, to make sure that the European Union accedes to the convention, and that the European Union thereby comes directly under the jurisdiction, at least in some matters, of the European Court of Human Rights, everybody will be better off. And once this happens, then the European Court of Justice will, of course, use exactly the same tricks as the Poles use or as the Russians use in order to make sure that that not all of the case law applies in full to its legal system, but it will not come straight up with the same tricks in order to justify full non-participation in the system is the starting point. So as the point of principle, as the moral, ethical standpoint, any kind of claim that you don't need an additional check on your system of constitutional governance is flawed. And for now, I think in this sense, the European Union obviously is in a very problematic position, and it's up to all of us, for ourselves, to measure how far it comes, how bad it is, compared with the position embraced by the Hungarians, by the Poles, by the Russians, or any other members. And on UCOS, I'm not really interested in all these cases per se as cases. The only thing I'm interested, so I cannot enlighten anyone to my regret, but what I'm interested in is how the constitutional rot in terms of the basic preservation and honoring of supranational or international constraints on the absolute nature of local political power actually happens. And in this sense, Russia is a great example to study, just like as the European Union itself and several separate member states of the European Union. In this sense, all this Sharpson saga was quite a revelation, because plenty of scholars somehow find it unpatriotic to criticize the highest court of the highest courts of own systems, and that's precisely why plenty of some really famous, top-notch legal scholars willingly and knowingly joined the fake institutions created by the Prawo i Sprawiedliwość in Poland, something that you wouldn't expect them to do. And the same when I started writing about the Sharpson cases with Graham Butler from the University of Aarhus, we received suddenly hundreds and hundreds of quite personal and graphic emails explaining to us that we shouldn't be full stop because we are not the patriotic supporters of the EU legal system, and because it doesn't matter what the Court of Justice does with its own members, as long as it doesn't mean it, and it's absolutely impossible to compare the application of Article 19 to the Court of Justice as opposed to its application to the national courts. And I beg to differ. So I have an absolutely radically different position on this issue. And the last point here there was a conference at the Hungarian Academy of Sciences a month ago where several prominent lawyers from the European Court of Justice were present, and they voiced a very strange opinion, which apparently, if we take them for their word, has some traction dans les couloirs of the Court of Justice, that the Court of Justice, in some instances, on some occasions, doesn't act as a constitutional court. It acts as an international court. What does it mean? It means that as an international court, it is absolutely bound to the will of the masters of the treaties, and it's not in the position at all to criticize the masters of the treaties, even when they act ultra vires, and even if they act in direct contravention of the law, when this happens outside of the areas which are directly mentioned in the treaties. If this is really the position of the Court of Justice, or if it ever becomes part of the case law, then we don't have the union based on the rule of law. Then we don't have European law, to my opinion. So I hope this kind of guys never prevail, because it's simply dangerous.
Thank you very much. I notice a question over there, so you can identify yourself and maybe ask your question directly. Yes, unless maybe for the people at
probably
home
you can
will
repeat
not
the
hear
question
it.
for the
Otherwise,
online audience.
I can repeat it, or if... Okay, maybe I will just intervene for the people who are following at home. Try to repeat the question and try to summarize it and be brief. The first one essentially concerns the question to what extent, following the formal appointment procedure and the formal rules, as apparently it happens in Russia with respect to the composition of the Constitutional Court, is that sufficient to draw conclusions about legality of the composition and the process, is how I understood the question. And the second question is how, when drawing the links between what happens in Russia and Poland, how this interaction, how the Polish system kind of learns from the Russian example, how this actually works in practice, if I think this is... How courts learn from each other. How does that works in practice? So that's the two very relevant questions, I think.
So these are all excellent questions, and I didn't make any claim that following formal rules is enough. It's never enough, usually, and we have plenty of examples why that is indeed so. But formal rules are there to be followed. So if we have a blunt disregard of formal rules, if legality is broken, not the rule of law as an umbrella principle, but legality, basic lawfulness as one of the fundamental elements of the rule of law, then what we are dealing with simply is not a court anymore. And that's the position of the European Court of Human Rights. That's also the position of the European Court of Justice. So if you are a lawfully appointed body, then of course you can be biased, and of course you can come up with some absolutely flawed doctrines and concepts. You can be unconvincing, but you are still a court. So you are worthy of being engaged with in the legal context. If you are not a court, then there is really nothing to say. So in this sense, there is no comparison between the Polish Constitutional Tribunal, at least in the eyes of the European Court of Human Rights, and the Russian Constitutional Court. The Russian Constitutional Court is a court, a worthy interlocutor, and the Polish Constitutional Tribunal is a non-court. And it's a bunch of buffoons who are dressed as judges, but it's absolutely clear that, legally speaking, they are not. So these are absolutely different. These are different depths in the abyss, right? And if we throw Hungary into the mix, we have cases, important cases in front of the CHR, the Baca case especially, about how highest-ranking judges were unlawfully kicked out from the system. But then when they win those cases, there is nowhere to return to, because the Hungarians legitimately say, but our constitution has this number of places on Curia, for instance. Where should this guy, who unfortunately was unlawfully dismissed for his legal positions, for his views about inter alia human rights and other things, where should he return to? And the answer is, well, nowhere. That's the answer in the context of the CHR. So this is a kind of halfway restitution. You can get a compensation, but you cannot have the constitutional system of institutions rebuilt to the extent in which it's not tempered with. So you can create this semi-lawful or questionably lawful bodies also by simply kicking people out. And this is what happened with Advocate General Sharpston as well, if you want a supranational example. But still, this is something at a radically different level of absurdity and of tampering with the idea of legality compared with what we see in Poland as confirmed by the Court of Human Rights. So the threshold is extremely low. But once again, I will repeat this. I think it's a fundamental starting point if we speak about human rights. Sometimes the lower threshold, the better, because the regimes which are problematic from the point of view of human rights still benefit, or those who are under those regimes benefit enormously from the participation of those regimes in the common system of human rights protection, because however weak, it still provides an additional constraint on the absolute nature of national power. And in this sense, once again, morally, ethically, the standpoint of the European Union, or of the Court of Justice rather, is absolutely impossible to justify when we read Opinion 213 seriously. It's one of the most disgraceful cases that the Court of Justice unfortunately treated us to as European citizens. And the second question was about mutual learning. Well, actually, if we look at what Poles produce, they pay interesting lawyers to go through all the literature and all the doctrines and all the case law. So when the Prime Minister of Poland sends a request to the fake Constitutional Tribunal, it's not simply one question or two. It's a pack of papers with hundreds of footnotes which misquote pretty much every legal theorist and the EU law scholar and human rights scholar that you would respect. They obviously misquote plenty of case law from all the leading courts, especially the Bundesverfassungsgericht, and the court then would quote and would rely on what it received from the Prime Minister's office. That's how it happens in Poland. But importantly, the logic is always the same. That's why I read two important paragraphs to you. One of the paragraphs from that opinion 21P from 2016 from the Russian Constitutional Court, and another one which is its brother, which is its twin, paragraph 187 from Opinion 213. So as a European citizen, I am ashamed of the Court of Justice and of being under this system. But at the same time, of course, I clearly see the differences. It's impossible to say that the level of human rights protection in Russia is in any way comparable to the level of human rights protection in the European Union. But we should always remember things fluctuate. So if in exceptional circumstances or in some kind of unknown future, we could actually very much regret that there is no additional constraint coming from additional international level that would push the highest court in our system to comply with the basic ideas that all the members of the union individually, taken one by one, consider vitally important for their own compliance with the idea of human rights protection. So in this sense, I think the difference is quite clear. I hope this answers the question a little bit.
Yes, one other question from the audience.
Thank you very much for the very interesting lecture, and many thanks for making this comparative analysis between three approaches towards international law and human rights. My question is about doctrine of questioning legality of European Court of Human Rights. What do you think? What will be the main elements of this doctrine, and how often Russia would use this doctrine in practice in the future regarding the decisions of the European Court of Human Rights?
Okay, so I'll try to rephrase and repeat the question. So the question is about how often Russia will, or how it will develop the doctrine on questioning the legality of the European Court of Human Rights. So would only these few exceptional cases refer to, or will this further develop and further undermine? Is this a kind of trend that will undermine the legality of the European Court of Human Rights as such? I've understood your question. Yeah. And there is one additional, maybe follow-up question.
Losing my voice, now I'm asking questions. It's embarrassing, but following up what was just said here, I'm wondering, since I'm not capable of reading Russian and understanding Russian, how in the legal doctrine, Russian legal doctrine, the implementation of rulings of the European Court for Human Rights is perceived in instances where the Russian state is condemned by the court. So I have no idea at all, so I did not study that question, and I think it is somehow relevant in what I just heard here from another question. So could you elaborate a little bit on this point, please?
So again, for the audience following online, a follow-up question concerning the approach of the Russian doctrine with respect to the case law of the European Court of Human Rights, in particular in such cases where Russia was condemned by the European Court of Human Rights. And again, linked to the previous question about how the legality of the European Court of Human Rights is perceived in Russia, and also in Russian legal doctrine and so on. So
The questions are wonderful, and of course, indeed, they are connected. I'm not an expert in Russian national law at all, and I didn't want to wear that hat. So I'm here to make this very simple comparison at the highest level, but what I would allow myself to say is that there is no systemic compliance at all in Russia. Which means that if we speak, for instance, about the Dutch state, the approach to and the place of ECHR case law in the national system, national legal system, which is also a monist legal system, is radically different compared with what we see in the Russian Federation. And this obviously is reflected into the in the number of cases in front of the European Court of Human Rights that come from different jurisdictions. Russia being one of the leaders. In part, this is not the general disregard of human rights, but this is the general disregard of the idea of systemic compliance, because you can have plenty of the same cases essentially coming from the Russian Federation over and over again. It's absolute nihilism from when the question is approached through the Dutch eyes concerning the idea of fully taking on board what Strasbourg has to offer. But if we move on to the first question asked in this in this combination of questions, here I think, and the question was. The question concerned the kind of spectrum of illegality, right? Yes.
It's clear that it will be constructed by the Constitutional Court of Russian Federation. But the key elements, what are criteria be used to say that this decision of the European Court of Human Rights is illegal in terms of the context of Russian Constitution?
We have two clear examples now, which I referred to. The first one, which I think is which was the starting point, and which I think is a clear example of how this kind of case law could be convincing, is 21P, which I already cited extensively, when the court said there is an unchangeable part of the Russian Constitution. The Constitution itself says this part cannot be amended. You need to have a new constitutional convention and a new constitution in order to alter that part. So if the case law of the European Court of Human Rights requires the Russian Federation to dump the current constitution and to have a new one, then this kind of case law is probably going too far. And this is a fair starting point. So if there is a dialogue between the courts, then probably courts could at least check whether something is a constitutional right or a constitutional wrong, and how that can be amended. Because obviously when Russia joined the CVHR, there was a basic check of compliance of the CVHR with the constitution. The starting principle, as the Russian Federal Constitutional Court also explains, is that there cannot be any conflict. And in the absence of the case law of the European Court of Human Rights concerning the enfranchisement of prisoners, at the moment of Russian accession to the CVHR, it was impossible to predict, or so the reasoning would go, that somehow the Russian constitution would be in direct conflict with the convention system. So this is the most convincing part of it. Then once you say we don't want to pay 2 billion, that is probably less convincing. But what gives me optimism is that there were these two dissenters, Yaroslavtsev and Aronovsky, the two members of the court, who laughed at the opinion of the other members, who said that the case was at all admissible, even at that stage, and who questioned the motivation of the Ministry of Justice in bringing that case at all, because the only motivation seemed to be not to comply without having any solid, valid reasons. But of course, the courts need to be more convincing in democratic regimes than in autocratic regimes, because democracy, in part, survives through convincing the population that what the court is telling, actually, the ability of those who would read decisions to see that what the court is saying makes sense. And on this, there is a huge spectrum among the members of the European Court of, among the members of the European Human Rights Protection System. So the courts in Azerbaijan can be much less convincing and still issue whatever binding decisions, compared with the courts, say, in the French Republic, they're short. compared with the courts in, say, the United Kingdom. So these are very different traditions. And my hunch would be that, of course, Russia is not the United Kingdom. So you can be pretty brief and not necessarily, you shouldn't necessarily make sense as you, from our, say, British Western understanding in order to build a solid body of constitutional doctrine. But here, the main problem to me is not this attempt by the Russian Constitutional Court to build this doctrine, but in the emerging European trends, where this doctrine will not be a Russian doctrine. This doctrine will be a continent-wide doctrine. And here the spectrum of presumed okayed non-compliance will then go from Russia or from fully compliant states. Let's presume who can be fully compliant. The Estonians, who even officially proclaim that their constitution is under the European Court of Justice case law. Full compliance, they think it's okay. Or absolute non-compliance out of principle, which is the Court of Justice of the European Union. Because the Court of Justice of the European Union adopts precisely the same cherry-picking approach. This right is fine, and this right we have never seen. We are not members anyway. Which the Russian court wants to create for itself by justifying non-compliance. So in one sense, you have non-compliance as an absolute exception. In the other, you have free choice of what you comply with and what you don't, because the starting point, as the Court of Justice explained, is that actually you should not be bound in any way that would in any way distort the functioning of the internal market or the coexistence of the institutions of the European Union. So on this point, I think I will be with Yaroslavsky, with Yaroslavtsev and with Aronovsky, not with President Leonard's, with all respect. And then we have all the others in between. We have the Poles and the Hungarians, who are much worse than both. So it will be an interesting curve, because unlike the Russian doctrine, where the idea is full compliance, unless justified strictly in a particular case, what we see in the Polish case, which was sent today to the fake constitutional tribunal, is that the whole ECHR system as such and its position vis-à-vis Polish constitutional law seems to be in question. So this is going much further away from the Russian understanding of this conflict, and this is going also much further away. Well, in principle, it's probably closer to the European Union position, European Union own position, but of course, the majority of commentators will never put it that way, because somehow they don't treat the European Union legal order as a constitutional system which is mature enough to be expected to meet the same basic constitutional requirements which we always await when we speak about particular member states of the European Union. And this is probably the problem. This will have to change. So, in short, the starting point of the doctrine will be the exceptionalism of what is to happen in every single case when the court of the Constitutional Court of the Russian Federation would proclaim some decision of the Court of Human Rights ultra vires. In this sense, the basic premise, the starting point of the '93 Constitution is still safeguarded, is still with us. While the other part of the same spectrum is simply to say we are not the members, and that's the European Union's position or the position of the Republic of Belarus, which deserves much less respect. There is another question, I think.
Okay, one more question. Also looking at the time, I think this should be the final question. So try to be brief, but yeah, you can still ask the question. So please.
Within the European Treaty on Human Rights, we not only have the European Court on Human Rights, there are two bodies which have something to say about the execution of the decisions. First of all, Parliamentary Assembly. Secondly, the group of ministers, Court of Ministers. My question is, why do we hear so little about these two bodies whenever Russia lies the decisions because of providers next to itself?
Thank you very much for your clear question. So the question concerned the role of the Parliamentary Assembly and the Committee of Ministers within the framework of the Council of Europe that have a particular role to play in, let's say, monitoring the execution of the judgments of the European Court of Human Rights. So why don't we hear a lot about those bodies when it comes to non-compliance with the obligations by Russia?
It's an excellent question, because indeed everything is in the hands of those bodies. It's up to them to proclaim some decisions to be complied with, and others not. But at the same time, once push comes to shove, their powers are very limited. If the country adopted a clear stance of principle, which is directed at non-compliance, they cannot really do much if they don't want to lose the country's membership of the Council of Europe. So, what is the highest threat that they can deploy? That's the Article 8 of the statute. They can kick the country out, but by kicking the country out, you precisely ensure that the country's government gets a carte blanche and precisely disregarding any kind of human rights by eliminating any kind of source of external pressure in this field, which might still exist on the government, even in the case when the decisions are not the decisions of the European Court of Human Rights are not complied with at the national level. But then let's put the non-compliance in the context of the number of cases. So if we look at the cases where the European Court of the Russian Constitutional Court taught us that it was okay not to comply as a matter of Russian constitutional doctrine, this is a drop in the ocean, because the majority of non-compliance actually happens silently. The absolute majority of non-compliance will never be announced as a matter of principle. And this is what the majority of individuals and companies would suffer from in terms of seeing their rights protected under the convention or proclaimed under the convention being violated. So that's the trouble. But I think of course it's always helpful to look at those bodies. But and I saw that you disagreed. But I think if their leverage is really deployed to the full, then the threat is to lose it all, and to have the repetition of Greece in the time of the colonels, when the country is simply out, and then the supranational constraint or international constraint doesn't exist anymore. But here again, to underline the fundamental difference between Russia on the one hand and the European Union on the other, there can be non-compliance on the part of a non-member, even in the context when the member states themselves actually required the Union to accede. And that's probably a bigger problem. We're a little bit over time, right?
We're a little bit over time, but still, 5 minutes is still fine. But taking into account the time, indeed, I think we'll We'll arrived at the appropriate moment to finish this public lecture, so I would like to thank you very much for your insightful ideas, for your comments. Also want to thank the audience for the excellent questions during this evening, and I hope that we'll meet each other for another occasion, other public lectures that will be organized throughout the year. And I also want to thank the people following online at home and wish them a nice evening. So thank you very much.
Thank you.